Good evening, everyone. It gives me immense pleasure to welcome you all to today's webinar on group insolvency in real estate, navigating complexity under IBC, which is conducted by InCorp Restructuring Services LLP. IRS LLP is an IBBA registered insolvency professional entity and an insolvency professional with pan India presence. With a team of 200 plus professionals, including CACS, CMA, we provide, we are the trusted advisor to banks, financial institution, and corporate, and specialize in providing restructuring and stress asset management solutions. Now, coming to the today's webinar, the real estate sector, which is one of the largest contributor of GDP and employment in India, directly impacts millions of home buyers across the country. Yet, it is also one of the most litigated sector under the IBC. The fragmented nature of the real estate projects with multiple special purpose vehicles, interlinked financial structures, and overlapping obligations to creditors and allottees has often posed challenges in achieving the timely and effective resolution. Though we don't have a full and square law on group insolvency as on date under the IBC, but the IBC Amendment Bill 2025 has finally tapped the opportunity to bring this under the IBC radar. Today's discussion, revolving around the theme of group insolvency in real estate sector, will help us to navigate the complexities around the concept by drawing upon insights from law, practice, and policy. I am confident that our distinguished speakers will bring valuable perspective on how group insolvency, particularly in the real estate sector, can be shaped under the IBC framework. We are privileged to have with us CA Jayesh Sanghrajka, who is the co-founder of InCorp Advisory Services and the managing partner at InCorp Restructuring Services LLP. With over 4 decades of experience in corporate law, restructuring, and insolvency, he has resolved debts exceeding INR 30,000 crores, thereby safeguarding the interest of 10,000 plus home buyers. A seasoned leader in real estate sector, he is also a regular speaker and a thought leader on insolvency and corporate law. We also have with us Mr. Ashish Parwani, who is a senior partner at Rajani Associates, who brings with himself over 2 decades of experience in merger and acquisition, group restructuring, and corporate debt restructuring. He is widely recognized for advising on real estate private equity transaction and has played a key role in guiding funds on investment, exits, and related legal proceedings. With that, I once again extend a warm welcome to all the participants and look forward to an engaging and thought provoking session. Participants may post their questions in the chat box, which will be taken by the speakers at the end of the webinar. Thank you. Jayesh sir, over to you.
Good evening, everybody. I hope I am audible, Achal.
Yes, sir, you are. You are audible.
So Achal has rightly laid the background for group insolvency. And here we are focusing particularly on real estate matters. Group insolvency can happen in any sector, but I feel that real estate sector, which is one of the largest sector under IBC, which is around 20% of the cases are covered under real estate. So this topic becomes very critical. And initially, as we all know, the concept of group insolvency under IBC was not there. And it has developed over a period of last 7 years or 8 years when IBC came into picture through various legal decisions. The more details will be shared by our other speaker, Ashish Bhai and Dimple. But however, as we know that there was no concept of group insolvency. The insolvency law itself provided for a single debtor resolution. It never provided for group insolvency. But critically in real estate, there are the reason for group insolvency is that there are multiple companies and one project can be in multiple companies. We will elaborate that in our examples where there is already NCLT order received in case of Darshan developer, Videocon, etc. So here and there is an interlinkage between all this entity Plus there is inter company corporate guarantees and all that stuff. So resolving one company is not possible. So the resolution of one company is linked to resolution of other company, and that is the main challenge, and that is the reason courts have allowed group insolvency in certain cases. Three of our cases, the group insolvency has been allowed. In two cases, the orders are received, or one in one case order is received, and in one case the process is going on. So but there are multiple challenges for group insolvency. As I said, that there are no direct provision under current insolvency law. Because of that, there were challenges, and court have been proactive and have decided in favor of group insolvency in certain cases. However, it takes a lot of time through court process. So if there was express provision in the law that groups insolvency is allowed, then it will help a lot. So now the new amendment bill of 2025 proposes group insolvency. So IBBI and MCA has learned from the past experience, and there was a lot of debate going on for last 2-3 years for group insolvency. Now the law is being laid down, and I hope there will be more clarity and more discussion, and law will evolve, and provisions will be implemented very soon. So with this, my opening remark, and what are the common challenges as on today, which will be addressed under new law? Common bench. So we will have a group insolvency resolved through a common bench. Coordination among COC, IRP, and RPs will be easier. Common insolvency professional will be there, and joint committee of the creditors. Coordination agreement will also be there. Allocation of coordination cost also, and all these provisions are being proposed in the amendment bill. Now I request Dimple, who is a company secretary and who has handled two big cases of insolvency law. She is my team member. So over to you, Dimple.
Thank you, sir. Hello, everyone. Yeah, can you hear me? Sir, can you hear me?
Yeah, I can hear you,
Yeah.
Dimple.
Hi, everyone. Thank you for the introduction, sir. I'm very happy to share the stage with you and Ashish, sir. So today's topic is very interesting. Group insolvency is a subject which has been a topic of discussion for a very long period. However, a legal provision or a rule or a regulation has not yet come under the IBC code. If you look at the present IBC code, there is no structure, no framework for handling such huge, large scale cases. Generally, the group insolvencies are of the size of more than 1,000 crores. So, a requirement for such a framework is very important and is very immediately required. Although there is no framework, however, the IBBI in the year 2019 had published a paper on this. They had prepared a structure which is yet to become a law till now. Recently, the World Bank as well as the IBBI had various sessions in the month of March where the topic of discussion has very prominently been only around the cross border insolvencies and the group insolvencies. What laws are to be framed, who will be the major stakeholders, how the process works around, and to prepare a structure and to legalize the same in the coming times. So the IBBA is very much into the process of laying down the laws. However, we are not sure how soon it will work out. But in the meantime, where such cases are coming ahead, in this time, most of the cases rely on the case laws or the judgments which have been passed by the Honorable NCLT and the NCLAT, which Ashish sir would be describing going ahead. So, going ahead in this topic, the various issues or the considerations that an individual or an RP has to do in such a framework where specifically real estate matters are involved. We've listed down a few points which needs to be considered by the RPs. Firstly, ring fencing. So when you see at a project, when a real estate projects comes under CIRP, the RP or the other stakeholders, they need to first decide whether the CRP is supposed to go independently, like a single CRP, or whether the CRPs are to be consolidated together. The points that need to be considered at that stage to determine the going ahead process would be firstly ring fencing. Ring fencing simply means either you bifurcate the assets into parts. Certain assets would be taken over by the creditors, certain would be by the RA, or you bifurcate the assets and you continue the CIRP independently. But the challenge that would come in ring fencing is the value maximization. If the project is bifurcated, the value would definitely go down. So, in order, and the primary objective or the main objective of CIRP is simply value maximization. So, the value in which you are able to determine the most would be the best going ahead process that you need to follow, whether a individual CRP or a consolidated CRP. Then home buyers play a very crucial role. There might be cases where a home buyer is registered in one entity, whereas the financing of that project is done by the holding company or by the other subsidiary company. There might be situations where the allotment letter is issued by one company, whereas the registration is done by the other company. In this scenario, it is very difficult to bifurcate the home buyers between the two projects. The only way out for this would be consolidation of the CRP, so that under this one single head, these home buyers can be consolidated and the claims as well can be consolidated. Then the next thing comes is project specific decisions. Now, project specific, there might be situations where a project is financed by one of the group entity, whereas the security is created in the other entity's name. Maybe it's a joint development project where one is the owner, one is holding the development right. In this scenario also, it is difficult to bifurcate the project. Maybe the land is consolidated and it's not demarcated, so it's difficult to bifurcate the land as well in two parts. So consolidation is the only way out in such a situation. Then comes in the secured lenders. If there are common lenders, if there is one single lender in both the entities for the project, then it becomes very easy to form a consolidated COC so that the project together can be given out to the RA. If there are multiple COC members, then there are difficult challenges. You need to determine how the decision making happens, and then you have to take a decision whether you want to go for consolidated CRP or an individual CRP is the best way ahead. Then comes the committee of creditors. Again, the same issue. There is a conflict of decision if there are multiple COC members. Also, if there are home buyers, the priority has to be given into what the home buyers require, which is the houses. The secured financial creditors' priority is recovery of their loans. So the priority of the COC is also to be determined, and accordingly, the decision has to be made. Then there are issues where there are cross guarantees, where one entity has given a corporate guarantee to the other entity. There, here as well, it is suggested and it is recommended to have a group insolvency because there will be duplication of claims. Then comes in the major player of the entire CRP, which is a resolution applicant. If you look at the resolution applicants, their priority is either to develop the project. Second, maybe they are looking for taking over a company which has huge losses. So, depending on the requirement of the resolution applicant, they would be infusing their funds. Now, if there are some obsolete assets in a company, whereas the other company has huge assets, in such a situation, if the companies are consolidated, CRPs are consolidated, such obsolete assets can also be given over to the RAs in one single basket, and there will be more chances of value maximization in such a scenario. Then comes in the administrative complexities. There are multiple issues. There are timeline issues in a consolidated CRP because you need a lot of time to consolidate the matters. Litigation takes a lot of time. There are compliances with IBBI, with triple IPC, ICAI. There are compliances which need to be done with NCLT. So there is a lot of challenges. Then there are other statutory authorities such as the PF, the income tax authorities, GST, ED, CBI. There are a lot of duplication of such processes if the CRPs go on independently. Whereas if a single litigation or a single matter can be handled in a consolidated CRP, that definitely saves the CRP cost as well as it reduces the chances of duplication. Then the major aspect that needs to be considered while deciding is the overarching goal, which means what is the goal of the COC as well as what is the goal of running the CRP process. Is it to complete the project so the home buyers get the houses? Is it to ensure that the recovery is the maximization is the maximum for the secured financial creditors? You need to as well look at the other stakeholders, which are the operational creditors, which are the government authorities who file their claims. So the objective needs to be very transparent, clear, and determined before taking a step ahead into consolidation of the CIRP and taking the entire CIRP as a group. Then who are the stakeholders involved in such processes? The stakeholders are common, which in a single CIRP, and an isolated CIRP and a consolidated CIRP have the same stakeholders. That is the home buyers or the allottees. Also, other than the home buyers, if it's a if it's a slum project, then there would be slum dwellers. Then there are secured financial creditors, which are the banks, the NBFCs, the ARCs. Then there are operational creditors, which are the contractors, suppliers, various service providers, operational creditors, which are the statutory and the regulatory authorities. Then after these stakeholders are together consolidated into a COC, that is the committee of creditors. Other than these parties, there would be the major party, which is the resolution professional, the major stakeholder, who would be running the entire process. NCLT, who is the jurisdiction authority, and then comes in the picture the resolution applicant, who shall be responsible for taking over the entire asset. Now, what are the legal or the practical aspects which impact these stakeholders? Now, if you look at the consolidated process, the challenges are quite different than what we face in an isolated CIRP. Number one is jurisdiction. A jurisdiction in an isolated CRP is very simple, the bench in which it got admitted. However, when you go for consolidation, the challenge is that the CRPs are admitted by multiple entities. There is not a single bench for each of these entities. You need to go to the principal bench, you need to get all the matters under a single bench. Then, after that, the COC has to file an application for consolidation. In that situation, a lot of time, approximately you can estimate 6 to 7 months, goes in the only process of bringing all the CRPs under a single bench. Then second challenge that comes in is the claims verification. There might be issues of double claims where the claims have been filed home buyers in both the entities when they were under single CRPs. There might be issues of secured financial creditors who are a party in one entity, who are a COC member in one entity and may not be a COC member in the other entity. So these kind of issues become a challenge in the consolidated CIRP. Can you see my screen and the legal and practical aspect screen?
No, we are.
Dimple, your group insolvency screen is getting reflected. Slide 5.
Okay, okay. Is it visible now?
Yes, yes.
Yeah. Yes. So we were at the point of claims verification. Now comes in the COC composition. There might be issues where the COC members in one entity are different and in the other entity are different. And the challenge to consolidate them into a single consolidated COC is a problem. Also, when there are home buyers, there might be ARs in all these entities. The challenge comes in that who would be the major AR in the consolidated entity. For handling these kind of challenges, the major role that is to be played is by the IBBI to lay down a procedure or a framework to uh, resolve these issues. Then comes in the challenge of timeline, as we've discussed above. A lot of time is gone in litigations, transfer of these matters under single bench, then filing consolidation. So 330 days period is a very normal period for a consolidated CRP, which goes in litigation itself. Then the CRP, again, the timeline starts with a fresh timeline from the first date. And to get an extension or an exclusion from an honorable NCLT bench is not an easy task. Some benches are quite easy to give the timeline. However, we have been facing challenge in some of our cases where it is very difficult to convince the bench because there is no procedural framework under the code. So the code also relies on the various judgments which have been passed by the other benches. Then comes the challenge of the information memorandum, the valuation. Although the IAMs have been prepared independently by each of these entities, since we have a timeline of 90 days, you need to prepare a consolidated IAM as well, which is necessary, because on the basis of consolidated IAM, only the RA can give in the project, given the EOI. Then there is an issue of valuation. The challenge in valuation is that if you look at the securities and financial asset valuation, the valuation is done on the basis of the balance sheet, which can be done independently for each of the entities in the group. But if you look at the land and building aspect, you cannot bifurcate the land, or you cannot bifurcate the project, or you are not able to bifurcate the revenues generated out of these projects. In such a situation, valuation cannot go ahead unless the consolidation is allowed, and the true value will only reflect post consolidation if considered as a single project. If you bifurcate it and do the valuation, then definitely it would not reflect the true value. So valuation is another challenge. However, there is no framework under the code, and the RP has to take the risk of waiting till the date of consolidation, only after which he can do a single valuation of the entire project. Then comes in the resolution plan. The challenges that an RP face over here is that the size of the consolidated projects are very huge. They are never below 1000 CR. To pick up such a project, or for an RA to come in such a project, you need a huge sized RA, and it is very difficult to find such RAs who are having such capacity to take over the such sized projects. Then there is also cherry picking. The RAs want to bifurcate the assets. They are interested in only some projects, they are not interested in other projects, to find a buyer for such projects. Then the COC and the RA may bifurcate the projects amongst themselves. So these challenges are faced by the RP during the entire CRP process. Then comes in the regulatory compliances. If you look at the regulatory compliances, number one is IBBI, where the RP is supposed to do the all the regulatory filings. Earlier there was CRP form CRP 127. In our cases, we have been facing huge challenges in these filings, because now that the consolidation is done, the status of the CIRP is common for all entities. However, since the entities reflect individually in the IBBI portal, we have to file multiple forms reflecting the same status to IBBI. So there is duplication of forms, there is duplication of work that we are doing, and there is no forum at the IBBI portal to complete these filings in a consolidated manner. Similar filings for income tax, for GST, the RP has to liaison with each of these authorities for each of these entities independently. Looking at the size of these projects, it's a very huge task. Then comes in the stakeholder conflicts. Obviously, there would be different priorities for each of the stakeholders when the distribution of funds come in. The home buyers would want houses, the SFEs, the secured financial creditors would want funds, would want recovery of their funds. So in such a situation, it is very challenging for an RP to make a balance between the COC commercial wisdom as well as the judicial precedence. Then the practical challenges that we face, if we'll discuss this on the basis of one of the case that we recently done, that is Darshan Developers Private Limited. The CRP involved 11 CDs, a single project, a single land parcel which could not be demarcated. Now,
Dimple, sorry to say, can you move to that slide? Because here it is legal and practical aspect. So
uh,
slide, yeah, of Darshan, yeah.
okay, okay, sir. Can
And
you see?
as Dimple was saying, these matters are really complicated in group insolvency, and she has very nicely explained various steps involved. See, major issue here is the financial interconnection between the various units, and how are between the various companies, and how are you going to address it. So there now Dimple can explain about Darshan, what exactly the challenges were faced.
So in the Darshan case, we had 11 corporate daters, one single land parcel which was not demarcated as well. So the challenge was that individual CRPs could not go ahead because the land or the project was not, we were not able to bifurcate it. In that situation, the only way ahead was consolidation. Now, each of these CIRPs have been admitting individually before the bench, and after the admission till the date of consolidation, a lot of period was lost. We had to apply multiple times for extensions, for exclusions. We had to apply for transfer petitions, then we had to apply for consolidation. Post consolidation challenges were there. A single form G was to be published. However, due to the size of the project, which was the debt size was approximately more than 13,000 crores, it was difficult to get an RA. We had to publish the form G more than 3 times. Various investors showed interest. However, it was very difficult to get a plan in the process. Then the challenge was that IBBI compliance of issuing 11 form Gs was difficult. There were timeline issues, multiple extension applications were there, duplication of filings was there. So, Darshan Developers has been one of the landmark cases in which we have been able to resolve as well as bring in an RA. And the Honorable NCLT had recently passed the order for resolution in the month of June. This has become one of the major landmark cases for consolidation. I would like Achal to take this ahead.
Thank you, Jayesh sir. Thank you, Dimple, for deliberating on the concept of group insolvency in real estate sector in detail. Now I request Ashish Parwani sir to take the webinar forward, discussing about the legal issues that still revolve around this complicated subject. Over to you, Ashish sir.
Thank you, Achal. Nicely summarized by Jayesh Bhai and even Dimple. This is really nicely summarized. In fact, the RPs, how they function and how difficulty they face in the insolvency, it doubles up. In fact, 10, 11 times in Darshan case when we handle with them, it was 11 times, multiple issues came up and we successfully handled that. So, uh, Dimple has rightly pointed out so many issues we face. Not only in this matter, so many every matters where real estate is always a complex case. But it multifolds when you have the group insolvency. But that's the way it works and that's the way issue is. So we'll just take this forward. So let's take a background from this. Rajani Associate. So Rajani Associate is a full law firm. We are basically just put this right up. Yeah, we established in 1999. So we specifically handle many cases altogether. We don't have any other office, but we have all association all over India as well as in US, Middle East, all over world where we can handle the clients altogether. Our core practice areas are mergers, demergers, your acquisition, capital market, debt restructuring, dispute resolution, real estate, banking, and finance. So that's what our core practice areas are. Now, of course, Jayesh has already handled all these things. So our main this is sorry. So with InCorp we have handled many cases. Of course, thankfully we handled many cases in InCorp. The 11, 10 cases already handled with them. With all real estate transactions all handled with them. That is completely completely good for us so that we have handled this case with them. Coming to our topic, group insolvency, it's not it's ideally has been said that it's not been defined anywhere. It's the cases where multiple entities of single corporate group where they can handle with one foot, one forum, and ultimately handle with as a whole, restructure as a whole, and ultimately it's best interest in all group together. We are all pulled into one, and it's a single economic unit where we can handle this case completely, and ultimately all procedure has to be taken into account. And this is currently IBC does not have a statutory framework. Equity this is statutory framework today, as rightly pointed by Jayesh Bhai. Initially it was the insolvency law committee which has ideally provided this complicated subject, but it said that we will not take it forward. Ultimately it will be decided by the we'll take it forward afterwards when the system is fully established. But during this whole period, ultimately the even this principal model law of code, ultimately they also had said this, where it will be a worldwide, this the cross-border insolvency worldwide. It has been taken into account where model law, there is a model law of enterprise group insolvency which is going on, which is ideally was there, and this has been taken into account. But the UNCITRAL has already taken this account, and in this scenario, all this has been taken ultimately, and in this case, ultimately, all this now group insolvency is coming to effect. Okay, so ideally there was no case specifically from the there is only Videocon, which is the first case ultimately which decided that SB the Videocon the first case where it ultimately decided when the consolidation can happen. Out of 13 companies, out of 15 companies, 13 companies were consolidated. The 14 factors which have been determined by the NCLT was this. It has to be a common control, it has to be a common director, has to be a common asset or common liability, some linkages, some interdependence on companies, some pooling of resources, coexistence of survival, intricate subsidiaries, linkages, intertwined accounts. All this thing has to be intertwined. There has to be some connection where you can consolidate these full assets. Otherwise, this whole thing will not be functioning. Ultimately, NCLT has to look into every aspect where all has to be consolidated and all has to look into these all test factors. They has to test, every test has to be there whether this can be consolidated, or then only this can go ahead further. Of course, the NCLT decided that two companies cannot be merged. Only this 14 company can be part of the consolidation. This is the second case where there were five landowners and one developer. When ANCLAD decided this, they have to be consolidated. They did not do the additional four companies. They completed this because five landowners and one developer. They allowed ANCLAD allowed this to consolidate into all, and ultimately they have consolidated this, and ultimately in 2019 this admitted NCLT admitted all these five companies. This is another case where the subsidiary was holding the land, and developer was in the CIRP. The NCLT decided that this has to be taken into the company. It's a common linkage between the asset between the company as well as in the subsidiary, and ultimately they directed the NCLT to take into account and put this company into consolidation, and ultimately that subsidiary was recently involved in the admitted in insolvency and making way for the consolidation thereof. And this is our case. Darshan Developer, we consolidated every company. This 11 companies merging into one. Where this slum rehabilitation, Dimple has rightly pointed out, all slum rehabilitation scheme in Ju Andheri. There was shared, the common features were they shared land parcel, common security interest, common directors, common ownership, signatories, the same resolution of a professional appointed judge was there for all 11 CRPs. So there was decision making where ultimately they decided that this will be consolidated based on various judgments on the NCLT with all Lavasa and all these things. They ultimately decided to consolidate this whole. The complexity in this case, there was a complexities. What we have to consolidation is one part. Ultimately, this has to be consolidated with filing this section. We have to file separate companies, filing for all separate companies, and ultimately you have to file separate 92 non-corporation, separate forensic, separate avoidance transaction. Although the consolidation is one part, but ultimately this has to be all procedure has to be followed for all 11 companies separately. That will completely handle this whole process. And ultimately, this has been approved. Now, this plan has been approved and has been approved by Chief Infra. This has been approved under 100% COC approval on June 27, 2025. So, advantages is rightly Jayesh Bhai and Dimple rightly pointed out that it reduces the information gap. It gives all fair conduct to all CIP. It impels all information are there in one place. It becomes clarity for investors also. They can clarify this everything. There is no less of confusion about what investor will be clarify. There will be saving of time also. no time, multiple investigation, multiple, it can be done in one entity, one consolidated manner. It will be cost efficient and it will be maximizing the value. That's the idea, to have a maximization of value, a better oversight of avoidance transaction. It will be the better way to do it. Avoidance the transaction, it will be oversight to have a one consolidated, one inter-se promoter group where you can have a oversight of all avoidance transaction. We can pool across and we can file the avoidance transaction. The challenges are there, which Dimple has rightly pointed out. There are many loan profile, various security interests are there. There are very hierarchy of different secure creditor which have to take into account when you go for insolvency. There are multiple joint developer partners, multiple set of home buyers, slum dwellers, stakeholders, and all group insolvency would be challenged. Where ultimately this whole group insolvency, ultimately slum dwellers, all has to be looked into. They have to see on consolidation whether they may dilute the stakeholders right. Then all multiple partners are there. We'll have to look into the aspect whether the consolidation, which will affect the whole process of consolidation, and ultimately that's the way it works. Completion of CRP within prescribed timeline is ultimately it has to be, this will that potential delay on involved getting a CRP. There will be delay in the complex group restructuring. The timeline gets 330 days gets elapsed. It always has extension of timeline, exclusion of timeline will have to take. And that's the way it works, because it takes really a lot of time to complete this whole process. So there's cross guarantee. There's a issue of cross guarantee, intercorporate guarantees, common contractors. All has to be looked into. They may change because your consolidation may change the voting share of creditors substantially, which may affect the decision making. The dispute, this may lead to more dispute, more litigation. This may delay further process of dispute and litigation. So recently, the IBC, the 2025 bill has been put in before the Parliament, and we have ultimately this will be taken into the law and once passed by the Parliament. So ultimately, this is the group definition which has been taken into account. The control definition, which where has the majority of director or where the management of the affairs of the company, the control and management and policy decision, and personal acting in concern, directly or indirectly, by virtue of shareholding and management rights or ownership right. This is the definition where it will be controlled, will be factored, and the group where two or more corporate entities are interconnected, which include holding company, subsidiary, associate company, and the significant ownership also, where you have more than 26% of voting right. So in this scenario, the group company will be determined, where who will be the group company, which can be done comes under the umbrella of consolidation or way of consolidated CRP. So this is another bill which will be ultimately rules will provide, the government will come out with rules where they will have a common bench, where there will be a coordination of proceedings, where there will be a common insolvency professional, where there will be a joint committee of creditor, where there will be a coordination agreement, where there will be a treatment of cost. So all this will have to fact. There will be a rule separately coming on this aspect. Once we come out, then we'll come to know exactly how this will flow. So this is the objective. Ultimately, objective is to have better coordination with insolvency and liquidation of group companies, maximization for value of stakeholders, and ultimately there is one more provision which is coming up here, is consolidation of guarantors' property in the insolvency. The bill is currently providing section 2, section 28A, where the guarantor's asset will be also put in the CRP of the corporate debtor, and ultimately this will be sold together, where the creditor have the possession of the property. This is the bill, still is not enforced, but once the guarantor's property can be sold in the CRP when the possession is be there with the creditor, and in that scenario, the certain terms and condition will be there. In this, where all you can sell the CRP can sell even this asset of the corporate guarantor also, or personal guarantor asset. So thank you very much on this, given me the opportunity to speak on this topic.
So Ashish Bhai and other team members and other participants, I would just like to add that whatever said and done, there are in finance world, there are lot many type of structures. In corporate world, we see joint ventures, we see project in partnership and execution by development company, which is a private limited company or a limited company. So all these challenges are will always be there, because as on today, partnerships are not covered, proprietary ships are not covered, joint venture or associate AOPs are not covered. So this all challenges, even under the new law, new under IBC law also, I don't think it is going to be easy to cover all this type of entities. Amit has raised some query regarding, if there is a non-corporate entity. Amit Gupta has raised a query. According to me, it is very difficult to cover a partnership or a non-corporate entity in this group insolvency also. But ultimately, it will be wisdom of Honorable NCLT as well as COC, and the law should develop on that point also. We are facing similar challenge where a land parcel is in partnership and the development rights are with the private limited company. And we are not able to move forward because partnership, in spite of 99% holding in partnership, we are not able to move forward because the one partner, the original promoter, is not cooperating. So these challenges will remain. How do we consolidate this type of entities under new framework? That time will only say. But I'm pretty sure there will be some solution in this aspect also. So other thing what I would like to say is also that our two ongoing cases are there. One is Sigitia Group, where consolidation is already approved, and there is another case which is ongoing, which is a large project in which the title is in three companies, and one company has been admitted and two companies are not getting admitted for last 2 years. So we are trying to address that issue, but these challenges are still there. And other thing, as a chartered accountant, as auditing professionals, and as for accounting standards, how are we going to meet accounting standards in this type of resolution? That also we will have to consider. Then the best, I think, international group companies or international subsidiaries, how do we address those type of issues? That also we will have to all consider. The other challenge will be I think the best model to follow, and what we are trying to follow, is also Singapore model. And Singapore model is getting evolved, and they are also there are cases of group insolvency in Singapore, and which I think we can study, and our lawmakers and as a resolution professional, we can try and implement. So I'm happy here that Subodh Agrawal ji is also there here, Devang Sampath is also there, and many other, Amit Gupta is also there. Many friends are here. So I'm happy if there are any queries or questions, please let us know.
So
Anything
there is
from...
one more question for you. Like, what are the valuation challenges that RP faced during the group insolvency?
So valuation, as Dimple also has mentioned, that if there are, in particularly, see, in real estate, it can be a slum project. And in slum project, there is one LOI and the ownership of the land is not there in the company. But LOI itself is a valuable asset. And it is bifurcated in 11 companies, but there are undivided rights. Undivided rights in the sense that 11 companies own undivided rights in the particular property. Same thing can happen in a revenue sharing model or a development agreement model. So there also same challenges will arise. So definitely there are challenges in valuation, which needs to be because there are a lot of what I find is that a lot of valuers have got very good knowledge of this type of projects in Mumbai in particular, because they deal with all this type of redevelopment project, they deal with SRA project, they deal with MADA project. So they have the valuation methodology which is really helpful for RPs. That is my view.
Noted, sir. Noted. Ashish, sir, my next question is to you. How are the intercompany claims and the cross liabilities being taken care of in case of cross-border, in case of group insolvency in real estate?
It's a very complex question because today the inter-creditor disputes are the main dispute which are going on in NCLT from ages. So ultimately, it has to be resolved the inter-creditor dispute plus hierarchy. The creditor, the first charge holder, the second charge holders, all issues are very, very critical. where we'll have to deal on each case-to-case basis. It's time consuming, but ultimately this has to be decided by the bench on case-to-case basis. So it's very in consolidation becomes much more difficult, where ultimately who is, because some creditor must have the first charge holding, some creditor will have first charge in other project, some creditor will have first charge in second project. So all these things will have to look into in every case to case basis, and ultimately decided on case to case basis, because this is very difficult situation where consolidation ultimately will decide on case to case basis, and where the projects are there, and we'll have to look into one case where how things can be solved.
Noted, sir. Jayesh, sir, one question to you. What steps RP should take to ensure that the home buyers' interest is safeguarded to the largest extent? Sir, your mic is on mute.
Yeah. So in case of group insolvency, RP's rule, because to identify the home buyer's interest in various projects is very challenging. If one case is admitted and some other two, in our case itself, there is an issue that two cases have not been admitted. But so we can't resolve one company unless we have the claims of the other two companies. The process is going on. So this is the big challenge. How do we, and there are home buyers in that other two companies. How do we identify those two companies' home buyers? And even after identifying whether we can admit their claims, that is a big challenge, because as such the ongoing process is for one CD, and home buyers are in second and third CD. How do you cannot admit their claims? But if you want to resolve this one particular company, you have to consider claims of all the two other entities. And that is the reason group insolvency becomes very, very critical for us. And in group insolvency, it may so happen that there are multiple projects and multiple projects in one land parcel, and there may be, say, 15 towers. Now, rights of these 15 towers may be spread into three companies. How do you address these issues? Where home buyers' interest, how it can be protected? This will be a big challenge, but ultimately RERA and law will help us to identifying home buyers for all the projects, and how do we address their claims, that we have to consider. That is my view.
Noted, sir. Ashish, sir, one last question to
And
you.
yeah, sorry,
Yes,
Amit
sir.
has
Sorry.
raised
Yes,
one
yes.
question of Darshan. So Darshan, briefly, again, if I have to explain, first, the main company Darshan was admitted, which had all the development rights of of the SRA project, and it had given assigned rights in 10 different companies, and these 10 different companies were admitted later on. So we requested Honorable NCLT to consolidate all this process, and that has happened through NCLT order from Delhi. So that order consolidation and same bench transfer, all the cases were transferred, all the 10 other cases were admitted, and then the whole process started. In brief, that is what has happened in Darshan Group. Dimple has explained in detail, but now since the case is already resolved, we can explain you in more in detail. That is what has happened in Darshan.
For participants to understand the Darshan case in detail, I will share the link of our success story booklet where we have deliberated on how this Darshan case was dealt. I will share the link of that booklet in this chat so that you may all access it later. And now, coming Ashish sir to you, my last question to you is project-wise insolvency is also one concept which has gained traction in the real estate sector. So for an RP, how he should decide that whether he should go for project-wise insolvency or whether he should go for group insolvency, because both the concepts has their own pros and cons.
Okay, see, project insolvency depends, its complexity all depends on how many developers are there. Sometimes there's one developer, one project, one home buyers. Then you have to do it in one CRP. You can complete in one CRP. Where there's a land ownership is in one company, land development right in another company. That's again a challenge where you'll have to see whether then there's a fit case for consolidation. Ultimately, we'll have to see on case to case basis. If there is only one set of home buyers, one set of partners, and one set of project, then you can do it in one project, one company. But then there's a multiple stakeholders involved, multiple projects involved, multiple phases involved, or multiple developers involved, in that scenario, we'll have to go consider for consolidation. That's the way it will work. The consolidation will be much better for that kind of project where there are multiple parties. And suppose there is a guarantee or there is a land ownership issue, there is a development right issue. So all these things can factor where you can have consolidation will be better option in that scenario.
Thank you, sir. Also, thank all the participants who took out their time and were there to attend this webinar. This is the first of our series. We will be conducting the multiple webinars on monthly basis. We will keep you all posted on all the webinar whenever we will conduct it, and we'll share the recording of this webinar soon with you. And for any queries regarding the webinar or the ongoing developments in the insolvency and bankruptcy code, I will be posting the email address where you can post your queries to us, and we will be happy to assist you. Thank you, everyone.